This is Elizabeth Townsend, and this is a interview with Ted Schmidt. It is April 4th, Wednesday, and this is our first interview with an alumni. We've been doing faculty all last week.
Great.
So we have lots of questions, so we'll just get started from the first one. You had said that you wanted to talk about big firm, small firm, medium firm, and why don't we start with that and sort of.
Okay.
And I guess my question is sort of what exactly should we talk about? Maybe sort of.
Well, I don't know for sure, but I guess I thought it might be of interest that I've had experience in all three sizes of firms, and I've had the experience of practicing for about 10 years in Phoenix and about the equal amount of time in Tucson. So not a lot of people have probably done that, and that I might have some ideas about the differences between the cities and the differences between being in different size firms that would be of interest. So.
Well, let's start with the differences in the cities.
Okay.
Where did you start? Did you?
Well, when I was in law school, I interviewed primarily with Phoenix law firms. I was raised in Glendale, Arizona, and most of my family was up in the Phoenix area, and I kind of thought that I wanted to go back up there. And during the interview process, I was told over and over again, principally by Phoenix law firms, that if I really wanted to be involved in a sophisticated, higher-powered practice, that I had to go to Phoenix, that you couldn't find that in Tucson. So, and the Phoenix firms paid better. So, and my wife was from Phoenix, so it all seemed to make sense to go to Phoenix. So I started at a large firm, Jennings, Strauss & Salmon in Phoenix, and I practiced law there for about 4 years. Then I moved to an even larger firm, which was O'Connor Cavanaugh, and I was there for probably another 7 years. O'Connor Cavanaugh opened a Tucson office, and in 1988 I came to Tucson to run that office. That office, although O'Connor Cavanaugh was a large law firm, was much smaller, and I was like the managing partner for the Tucson and the Nogales office, but combined, both offices combined, we had less than 20 lawyers. So that was kind of my, medium-sized firm experience. And then, about 5 years ago, I started my own law firm with 2 other guys, which has grown to where, I don't know if you'd call it medium or small, but we have 12 lawyers now. So I started in Phoenix and then came back to Tucson, and I still have a lot of cases. I still do a lot of things in Phoenix, but I'll never move back to Phoenix.
Why?
Well, Phoenix was actually a really good place to get started, and I really enjoyed the experience of working up there. But particularly later in my life, when I had 3 small children when I moved back to Tucson, and I think this is a much better community to raise a family, and it's more of a community. The practice of law is much easier in terms of personalities, in terms of contentiousness. Everybody in Tucson, I'm a trial lawyer, and I don't have a lot of dealings with lawyers in other areas of the practice, but in the area of trial practice, I have a lot of dealings with all of the lawyers that do trial practice, and I know all of them, and that's not true in Phoenix. In Phoenix, doing trial work, you could literally have a case with somebody that you would never ever have a case with again, that you might not ever even see their face. You may only deal with them on the phone. And that anonymity, I think, at least in part, resulted in certainly a less personal type of relationship with lawyers that you were up against, and made it easier for people to be jerks, because they probably would never have anything to do with you again. Same true for the court system. There are I would hesitate to guess how many judges there are in Superior Court in Phoenix now. It's got to be 75 to 100. In Tucson, it's 25. So I know all the judges in Tucson, and I appear in front of all of them fairly regularly. They know me, I know them. In Phoenix, that's not true at all. You could literally argue a motion in front of a judge and not be in that judge's courtroom ever again. Or if you were in their courtroom again, it could be 5 years down the road. And so it's much more difficult to develop relationships. In Tucson, because there are a lot fewer of us and everybody knows everybody, it's a lot harder to be a jerk. Because if you are hard to get along with, if you cheat, if you lie, if you hide the ball, then the word's out all over the street really quickly, and you won't enjoy practicing law here because you won't be part of the group. I mean, people will know who you are and the way you behave and will treat you totally differently. So I think there certainly are people that are not easy to get along with in Tucson, but comparatively speaking, far, far fewer people. And most of them don't, for whatever reason, don't seem to last very long.
Okay. In terms of, I'm in a negotiating class right now.
Okay.
And a lot of the class, even though we know each other, gets very aggressive and very sort of combative. And I wondered if you could talk about sort of your approach to that and also how it differs again in these two different settings, because it seems like you couldn't be really, really mean to people, and you had written about that in one of your pieces, and still have people deal with you.
Right. Well, I think there's some important distinctions to be made. There is, for example, a difference between being aggressive and being nasty. There's a difference between being zealous and being a sharp practitioner. There's a difference between doing the right thing for your client and hiding the ball from the other side, not being totally forthright about things in the case, about evidence you have, things of that nature. When you talk about comparison between the two cities, in addition to the just huge number of lawyers that practice up there, the large law firms are very large and dominate a lot of the areas of practice, recruit nationally, and bring in both law students and practicing lawyers from other states, particularly the East Coast, where I think to some extent stereotypes are correct. I've had the opportunity to litigate with New York lawyers and Washington, D.C. lawyers, and I've dealt with some very honorable people in that regard, but it's a different ball game. I mean, and it's a hard ball game is the way they play it, and there's a lot more. It's a lot more accepted to be deceptive in the way you practice, and it's much more acceptable to be extremely nasty in depositions, in objections, and in the way you treat adverse counsel. So I guess what I would say, and it's there. I don't want to give the wrong impression. Some of my best friends and some of the best lawyers in the state practice in Phoenix and are every bit as cordial and easy to get along with as Tucson lawyers are. But I think that for the reasons I stated earlier, it's easier to get away with not being as easy to get along with up in Phoenix than it is down here. I think here in Tucson, as well as Phoenix, there are a lot of lawyers that are, I would say myself included, that are very aggressive and fight very hard for their clients and are very zealous in their representation, but I think for the most part we don't misstate facts and we don't hide the ball and we aren't rude and discourteous. I mean, you can be very firm in a deposition and make very strong objections and keep a line of questioning from going where it shouldn't without name calling. But There are many lawyers who can't seem to maintain that balance. Just as a little side note, I had a case, just to kind of illustrate this point, I had a case a couple of years ago involving the Boy Scouts. And I have been myself very active in Boy Scouts. And so I was deposing a professional scouter who I knew in this case. And after the case was all over with, he and I went to lunch on something totally unrelated. He told me, you know, the thing I went back to the office and I was talking to everybody, and I just laughed and laughed and laughed, was I couldn't believe how sitting there in a deposition, how stern you were and the other lawyers, and you would debate whether this was an appropriate question or not, and there was even a certain amount of righteous indignation amongst you all, and then you'd take a break in the deposition and you guys would be talking about fishing, and you go into this thing, and you all seem to be very good friends. And that's true. I mean, so I think that it's probably a unique thing, particularly in trial work, but you can be friends and you can respect one another and get along fabulously and still be very hard fighters in the context of litigation.
Okay, I have a bunch of questions. First, in terms of hard fighters, do you find that all of the people are fighting hard in the same manner that you are, so that there's a sort of a culture of fighting hard so that you respect each other in that, or is that part of sort of being a trial lawyer, is fighting hard?
I think it is. I think it is with respect to the good trial lawyers. I think some people that aspire to be good trial lawyers are too easy. And probably more than anything, the single most distinguishing factor, personality-wise, is really, I think, guts. Because the thing that makes it hard to be effective as a trial lawyer is if people know you're afraid to go to trial. You're afraid of the courtroom. And law students have a hard time understanding that, because a lot of law students think about trial practice class as being one of their most fun classes, and how could anybody, that would be exciting, it would be fun, why would you be afraid to go to trial? But in real life, when there's a great deal of money at stake, when your client's whole life may be at stake, when you personally may have $100,000 of your own money invested in a case, and if you lose it, you're going to lose all of it. It's a lot scarier, and I don't think there are any trial lawyers that don't have a level of fear about trying cases. I think I guess the point I'm trying to make is some people find it so fearful that they never do it, or if they do, it's very rare. And when the whole litigation process is a constant evaluation of your case and the other side's case, and a key factor in that is the opposition. Is the other lawyer any good? Is the other lawyer effective in the courtroom, and is the other lawyer willing to go into the courtroom to resolve the case? And you get to know pretty quickly who is and who isn't. And if you're perceived as being somebody who's afraid to go to trial, you'll never get as much money on your cases. It's that simple.
All right, another question. Fighting hard. Can you talk about more what that means? And also, I'm thinking back to my negotiating class, there's a lot of talk about how hard do you fight when you know your client is not done exactly what they should have done, or if you're not sure, does that make a difference on how hard you fight and that kind of stuff? And what is fighting hard?
Okay. I think if you have an opportunity to interview some trial lawyers that do criminal work, you'll find that there's a difference. I think, and I can't really speak to that from personal experience because I don't do criminal work. I know criminal lawyers, and I've seen and talked to them about the way they do things, and I think it's a lot more hardcore because they're talking about a person's personal liberty and life or death, and it's a whole different ballgame in that arena. In the civil arena, I think fighting hard to me means principally. First of all, I do my judgment. I make my judgments about my clients and the merits of their case before I take their case. But once I take their case, then I'm their lawyer, and I'm not going to sell them short, and I'm not going to be second guessing whether or not their case is a legitimate case or not anymore. I made that decision. I agreed to represent them, and I'm going to give them everything I got. So I'm going to be, and I see myself, and I think most good trial lawyers do, I see myself really as their advocate. And whether I agree with them or whether I like them, whether I think they're entitled to this or not isn't really relevant. My job is to get the very best result that I can for them. So I think in terms of fighting hard, that means spending whatever amount of time is necessary to make sure that the case is properly prepared, that all the research is done, that I know all of the legal issues, and I've got the best possible arguments to make on their behalf, and to be willing myself to put not only the time but my own money into getting the best expert witnesses and presenting the case in the best possible way I can, and being ready to go to trial and willing to go to trial if I have to for those people. Now, I mean, that doesn't mean if my opposing counsel calls me up and says, hey, you know, you scheduled my client's deposition for next Friday and I was taking my family to Disneyland, that I'm going to say, well, I don't care, we're going on Friday. I mean, I readily give people, you know, some cut slack on deadlines and cut slack on when we're going to do things, but I don't ever cut slack on, you know, the merits of the case or what the case is worth or what we're willing to settle the case for, and I don't give slack when by doing so it's going to be detrimental to my client.
All right, here's another one.
Mm-hmm.
Best result. I did back to my negotiating class.
Okay.
When our problems, when they don't have money, our negotiations go very well, but when they're only about money, things get very messy. And I wanted to know what you thought about, like, what is the best result, and maybe if you have some examples of clients in terms of what their goals are. Are they always the same, or is it always money, or is it different depending on what the client wants?
It's almost always money, and there are times when, for example, a client really wants an apology, or they really want their case to make a difference so that other people don't have to experience what they experience. But really, when you get right down to it, by the time the case gets to the point where you're ready to do a settlement conference or a mediation, it's almost always money. And it's certainly money from my perspective. I mean, I used to do a lot of defense work. I still do some, but I primarily represent plaintiffs. So most all my cases are on a contingency fee. So the more money I get from my client, the more money I get. And so, you know, money is a big motivating factor for both of us. My experience is that people, more and more today, people tend to go into the settlement conference or mediation arena with preconceived notions about how much money they ought to be able to get. And these notions come from a variety of places. Some people have some friend who's a lawyer who's, you know, armchair quarterbacks and tells them, well, you ought to get at least this much money. But more often than not, that they have read things in the newspaper, or they've heard about some case in California where somebody was involved in a rear-end accident and had a neck strain, and they got $50 million, and so, doggone it, my case is worth at least $1 million. So I think that can and often does become a very big factor. I find that's one of the reasons why I think one of the most important things in mediation and settlement conferences is choosing the right mediator, right settlement judge, because some people are very good at it and a lot of them aren't any good at it at all. So if you get the right person, they are always good at dealing with those kinds of issues, and almost always when it gets down to the real crux of it, and where you really look, we're either going to make a movement here or we're going to walk out of here because this isn't going to happen, people cave in and they decide that, you know, I will take the advice of my lawyer, or I will listen to the mediator, and I am willing to negotiate lower than what I the blustering I was doing earlier on. And frankly, a lot of the times I get the impression that it's almost all an act for me and everybody else, that they're really adamant that. And I've had clients tell me, I had a case that I just settled about 2 months ago, where my client was adamant that we had to get $700,000 on this case, and he wasn't going to take a nickel less than that. And I actually thought we probably could get him that much, but the negotiations went on for a very long time, and at one point it didn't look like we were going to do that well. Ultimately, we settled the case that day for $725,000. Well, as soon as the case was settled, he then tells me, he says, "Ted, I can't tell you how happy I am, and I've got to tell you, I would have settled this case for $200,000. I bought a house. I put no money down. I made a deal with the guy when I bought the house that I was paying him cash, paying this house off by the end of this month. And I had to come up with $200,000. I have to have $200,000 or I'm going to lose the house." So, I had to do that, and I would have done that, and I didn't know anything about any of this. But that's not unusual. It's not unusual for clients to have their money already spent before they have it or before they even know what they're going to get. So, I think that, that was kind of an interesting little story of experiences I've had. But over and over again, I see clients, when it gets right down to it, they suddenly change. It's like they have a personality change, and now when they really realize it's fish or cut bait, they decide they're going to follow your recommendation. They settle the case, and they're happy, and everything is fine, and that's the end of it.
Okay, what makes a good mediator or a settlement judge?
Well, what makes a good one is one that, number one, is respected by the people involved. There's nothing better than a good settlement judge, because a judge demands respect initially anyway. A judge has power over parties and even non-parties that a settlement or that a mediator doesn't have. So, however, I will tell you that the culture's totally changed and nobody's using settlement judges anymore. But it used to be, that's all we did. Experience is good, but I guess the most important things for a good mediator or settlement judge is somebody who is willing to put in the time to read the stuff, to understand the case, that has had some experience with similar cases, and works really hard at getting the case resolved, and is willing to push real hard on both sides in the case, and is willing to be very aggressive in pushing a client or a lawyer or both to come up with more money or to come down more, and that have a good feel for people and good people skills, to where there are some mediators that I use that just they can figure out what makes a person tick. Sometimes they can figure my client out better than I have been able to figure them out, and know what the right things are to say to get them to become more reasonable. Empathy is real important. A settlement judge or mediator that just goes back and forth and pushes numbers is not nearly as effective as one that'll sit down and say, this must be terrible for you what happened, and please tell me about it. And when the client wants to vent to they're good listeners and they agree with them, and that's got to be terrible. But then bring them back to reality by explaining how the jury system works and how you could end up with nothing. And I understand what you're saying, but you do have this problem in the case because you had a couple of beers yourself before you got behind the wheel, whatever it might be. But primarily, I think being really aggressive with both sides and willing to really work hard and push hard and to get it done makes all the difference in the world.
What happens when you don't have a good settlement judge or a good mediator?
Almost always you waste a day and you don't get the case settled, and everybody walks away pretty unhappy with the situation. And you also tend to be unhappy because you probably made some movement in your negotiations that you would rather not have made at all, because you when you left, you really weren't any closer to getting the case resolved than you were when you showed up. But it's kind of like what I was saying earlier about lawyers. I mean, I think people know who the good mediators are, and those people are making a ton of money, and you can't even get on their calendar for 3 months because they get all the cases. And the ones that are mediocre, they don't get many cases because they're not getting the cases settled. The bottom line is a good mediator gets cases settled and gets most of them settled without spending 3 weeks on the case.
All right, let's switch gears.
Okay.
Let's talk about the daily life of the difference between a big firm, the medium firm, and the small firm. And sort of if you were a student and you wanted to understand, you're trying to decide what to do with your life right now, what is that life like? What was your life like in those places?
Well, the big firm is I would just say to any law student, if you have the option of going to a big firm out of law school, you should do it, absolutely, without question, no ifs, ands, or buts. And the reason for that is, I mean, there's a lot of negatives to being at a big firm, but for a new lawyer, the big firms have the resources and the experience and the know-how to train lawyers better than any other size firm. A small firm, just the lawyers in a small firm don't have the time to spend with a younger lawyer. There are exceptions, but they just don't have the time. The large law firms have programs. I mean, they want their lawyers to know what they're doing, and they bring them in, and the lawyers are being told on every Friday at lunch, there's going to be a lecture by one of our partners, and it's going to be really practical how to do stuff. And they're going to have some in-house seminars and programs. They're going to have mentors, a lawyer that's assigned to be your big brother or your big sister, and to make sure if you're having any problems that you can always come to them, and if you don't know how to do something, they're going to help you out. They're much better at evaluating you and critiquing you and giving you feedback because it's all part of the design. A lawyer can't give you work to do if they don't fill out an evaluation of your work so that there's a record of how, and on that evaluation form indicate I sat down with this lawyer and I told her what I thought of the project, and I gave her this criticism and I told her this was good, and that type of thing. The resources, library resources, computer resources, the availability to go to outside seminars, all of that is far, far greater in a large law firm. The ability to get a sampling. In a large law firm, you have the opportunity to experiment in different areas of the law to really find out for sure what you really want to do. Whereas most small firms nowadays, really aren't general practitioners anymore. People are specialized. So, I mean, a lot of people, I guess, know when they get out of law school exactly what it is they want to do, but not everybody does. And in a large law firm gives you more flexibility to try to find yourself and a large law firm, even if you find the area of practice you want, frequently they have so many different people doing that practice that you also may have options in terms of who you're going to ultimately be working with primarily. You may find you like this particular partner better than another one, and so you have more choices. Starting out of law school, the pay is usually better at a large law firm. So all of those are the pluses for a new lawyer fresh out of law school, and I tell all law students, if you have the opportunity, you should clerk at a large law firm for all the same reasons. You should go to work for one. And even if you hate a large law firms and you definitely don't see yourself being there the rest of your career, fine. But you should spend 2 or 3 years at a large law firm to get trained properly, to learn the ropes, and then go out and do your own thing or decide to hook up with a smaller firm. The disadvantages with large law firms are that they are far less they're much more impersonal because it's hard to know everybody. It's hard to know everybody's spouses, and you go to these social events, and it's intimidating, and the politics in a large law firm are incredible, and the longer you work at a large law firm, the more politics becomes a part of your life in that firm, in terms of your compensation and whether you're going to make partner or not, and who you're going to work for, and all types of things. Politics play such a big role, and it's harder to be an individual. It's harder to be different than the cookie cutter type lawyer that the large law firm's looking for. I mean, you want to play the part and do the right things so you can move up the ladder and progress in the large law firm, and those things can be really disheartening. It's kind of, to some extent, different large law firms are different from each other. So some are certainly more pleasant places to work than others. But I think that you tend to have more of a feeling of working for a big company, just not being, really doing your own thing so much in a large law firm. So I think, certainly the path I took was, I was in a large law firm for a very long time, and I was on the board of directors, I was a managing partner for a branch office and all of that stuff, and it was all a great experience, but I'm much happier today than I was then, being in a smaller firm and having my own firm.
Why?
Because everybody in the office I know very well, and we're very close, and we get along very well, and we talk and joke around and have a good time together, and I have absolute control over what I'm doing and what my firm's doing, and the quality of our work, I think, is better. I think that there's a higher level of commitment and pride in what we do. I think because everybody knows that we're a small outfit and we're all in this together, and we all benefit together when we do well, and people just give more of themselves they feel a part of it. Our secretaries feel like they're really a part of the law firm, because when we have a good result in a case, everybody gets a bonus, everybody gets rewarded, and people are proud of that, and so they're proud of the results we get, and they really, I think, give us an extra effort. So it's more of it's just a much happier atmosphere, and we don't have politics in our firm. I mean, everybody knows the way what's happening and how it works, and we all get along very well, and it's a real happy place to be.
All right, I've got a bunch of questions. Oops, sorry.
No problem.
Got a bunch of questions. First, before I forget, you mentioned the secretaries. What sort of is the role of the support staff, and sort of how do you treat them, and sort of what is your philosophy about them? Because I think that that's important for students to understand as well.
Okay.
And if that differs, if you're in a small place like you are versus a large firm.
I think that generally speaking, well, it can differ. One of the trends in large law firms is for lawyers to share secretaries. And the more you do that, the less you, I think, develop a close working relationship with a secretary, because she's not just your secretary. She's maybe 2 or 3 other lawyer secretaries. More and more larger firms use word processing centers. So like you're doing stuff and it goes into that room over there and somebody worked on it and you don't even know who it was. So again, it's less personal. In contrast, in our firm, in a small firm, this tends to be true in most small firms, we're like a team. So I have a secretary, I have a paralegal, and I have an associate that we all work together on the same cases. And we go to lunch, usually at least once every 2 weeks. And sometimes we talk about work and sometimes we don't. But I think that everybody is part of what we're doing more in the small law firm. We'll have lunch and talk about a case, and I'm just as interested in what my secretary thinks about some things as I am about what my associate thinks about it. And I really am interested in when my secretary tells me, spoke to this person on the phone, they want an appointment with you, they're interested in you looking at their case, and they're a really annoying person, and I'm going to tell you right now, I'll bet you this person has got a very inflated view of what their case is worth. And from hearing the whole story, it didn't sound right. It sounds to me like there's not telling us everything. Well, she's a pretty good judge of those kinds of things, and I won't make a decision based on that alone, but I like to have that input. So I think the way we do things in a smaller firm, everybody, including the secretaries, are a very big part of everything we do. And as far as the way, my secretary has to work very hard. She works overtime. She has to work on weekends sometimes, and she has, in trial work, there's always unbelievable deadlines and trying to crank stuff out. And I've found, and really kind of learned it the hard way, that you need to treat your staff really the way you would want to be treated. So I reward my staff a lot. I mean, I tell them they can go home early. I tell them, I buy them lunch. I give them, they do a really good job. I give them flowers. I do things like that, and they really appreciate it, and they go the extra mile for me. Because I'll tell you, if you have a secretary or a paralegal that they're just punching a clock and they can't wait till 5 o'clock and they aren't into the cases and they don't care about you and whether you do well or not, you're not going to be happy, and things aren't going to go very well for you.
All right, another question, but we're going to run out of time, so I'm going to ask you more questions.
Okay.
Billable hours, that's always a big question. Everyone's worried about how can you have a life and meet your billable hours. And again, I wanted you to talk about that, particularly large versus small firms.
Sure. Well, like in my firm, we don't do billable hours, so it's not even an issue anymore. But I used to be very good with billable hours, and I think there's more made of that than, I think the bottom line on billable hours is you got to learn how to keep track of your time. And the people that have trouble with billable hours are either lazy or they aren't good at writing it down. And if you get in the practice from the get-go of making time entries whenever you do anything, and you're willing to work reasonably hard, which any new young lawyer should be willing and interested in doing, I don't think that they're a problem. And I don't think the billable hour expectations in Arizona, Phoenix, or Tucson are really too terribly bad. So I think it's all a matter of learning how to do it right and to be honest about it. There's a lot of cheating on billable hours because people know that they want their numbers to look better, and so they're not real honest about how much time they spend on stuff. But that always comes back to haunt you. With the client or with the partner that's got to write off your time or whatever it might be.
All right, a couple more questions. Family, how do you, there seems to be a sort of, I get from these interviews that law is a passion. Most people, there's a sense of, there are some people that aren't passionate about it, and sort of it is all consuming, and that's sort of a culture that's part of it. How do you balance, or maybe not balance, or how do you deal with other things besides the law?
Well, I'm probably, and I've been told this many times, I'm probably pretty unusual in this category because my family is number one, and it always has been when I first got out of law school, I didn't have any kids. I had a wife, and I worked pretty hard for my first probably 3 or 4 years. I worked pretty hard, and my wife had a job too, so that really wasn't a problem. But once I had children, that changed. And my family has always been number one for me. I have been a Little League coach, a Scoutmaster. I'm a venture crew leader now. I'm going scuba diving with my boys and my venture crew next week on their spring break in San Carlos, and I've done a ton of stuff with my family. And the bottom line, to me, when people ask me, well, how do you do that? And to me, it's just as simple as how I manage to work out regularly. It's an important thing in my life, and I plan around it. I don't let other things interfere. So when my daughter has a softball game, I'm going to it. And if I have something that's going to conflict with it, I've even been in trial and told the judge, is there any way that today we could stop the trial at 4 o'clock because I'm coaching a Little League game and I need to be there by 5 o'clock? Sure, Ted, we can do that. So I very rarely have had a problem with it because I just won't let other things interfere with it. And most people, particularly in Tucson, if I tell somebody, hey, we've got this trial set for this date, but that's the same week that my family and I were planning to go to Aspen, Colorado, and we were going on this fishing trip. Would you agree to continue it? And people are, good for you. Yeah, I'll continue it. I think the problem that people have when their family, they sell their family short, it usually is a result of insecurity and feeling like they just have to do this or they're going to be a failure, and that they'll make it up to them later or whatever, and then they develop bad habits. I mean, it's like anything else in your life. I think if you develop good habits in the first place and you just make it a rule that nothing is more important than my family, and I'm going to make sure, I mean, I'm not going to be lazy or a lousy lawyer, and there are going to be times like when I'm in trial when maybe I don't have as much time as I would like to have with them, but I'm in trial maybe twice a year, and the rest of the time I'm going to they're going to come first, and I'm just not going to allow anything else to interfere with it. And it certainly hasn't hurt me. I've been very successful, and I haven't lost any cases or clients or anything else because of putting my family first. Frankly, I think an awful lot of my colleagues are very, very envious that I am able to maintain that balance.
On that, and we got to end soon, but on that, do you think that, I mean, you're in a position to be able to do that. What if you were a young associate? Can you still do that?
I think you can. I think this. I think, it depends on what your goals are and where you want to be. If you, for example, are looking at a large firm as your first place of employment, then definitely you've got to be committed for your first 3, 4, 5 years of working pretty hard and being willing to put that time in. And I think if you have a family at that point, they're going to have to suffer to some extent for your career. But I think in most areas of the practice, within 3, 4, 5 years, you've learned what you need to know. You establish a reputation, and you're going where you want to go. And if you can set those priorities and you can maintain it. It might cost you some money. You may not make as much as you would have if you'd build another, 20,000 hours that year. But it can be done, and you can still be successful if you're good at what you do and you don't, you do quality work.
Oh, we ran out of time, but
Okay.
this has been fantastic.
Sure.
Thank
Well,
you very much.
my pleasure.